Hello, everyone, and welcome to the first installment of Husch Blackwell's Fall Virtual Seminar Series in Labor and Employment. I am AJ Weisler, a partner in Husch Blackwell's Labor and Employment Group, and I am your MC today. We have a great lineup of speakers and topics to address, and we have attendees joining us from all across the country. Before we begin, I'd like to address a few housekeeping items for us. At the bottom of your audience console, there are multiple icons that you can use during today's program. For example, if you have a question during the webcast, you can submit it via the question box. We will attempt to answer the questions live during the webcast, and we will follow up afterwards if necessary. A PDF of the presentation and other resources are available in the resources folder. This program has been approved for HR and legal education hours. To report your hours, click on the CEU icon at the bottom of the screen, and a certificate of attendance and course numbers will be emailed to you tomorrow, along with a recording of the webcast for you to review and to share. Toward the end of the program, be sure to complete our short survey. We use your feedback as we plan our future programs. That is all the housekeeping items, so let's get started with the program. We have 3 sections of content, and each section will be about 30 minutes in length. We will have short breaks in between those in case you need to step away, but for those of you who stick around, we will be providing some additional information that we think you'll find both useful and hopefully a little bit fun. In our first presentation, Paul Potler, Rufino Gaitan, and Hillary Klein will discuss how to manage political conversations in the workplace, including possible protected activity under the NLRA. Next, we will have Eric Eisenman, Sunny Nolan, and Ann Mayette, who will review the top 10 questions that employers are or should be asking about work from home. And in our final presentation today, Tracy Wolf and Brian Hendricks will share workplace safety considerations as employees return to the workplace, including preparing for and preventing workplace violence. To start us off, Paul, Rufino, and Hillary, over to you in the studio.
Thanks, AJ. Good morning, all. It's good to see you virtually. Good for you to see us. It's good to get together. My name's Paul Potler. I'm from the Kansas City office, and with me today are Hillary Klein from Nashville and Rufino Gaitan from our Houston office. We are here to talk about everybody's favorite topic, politics, and even more fun, politics in the workplace. If you watch TV or you listen to radio or you follow social media or you just get out of bed in the morning, you know that we are in the ramp up time to the midterm elections. And the rhetoric is starting to heat up. So put on your track shoes. We've got a lot of ground to cover. Rufino is going to start us with the impact of the NLRA, the National Labor Relations Act, on workplace related communications. I'll follow after that with some more discussions about more purely political topics at work. And then finally, Hillary will bring it home with a discussion of voting rights and voting leave. So I want to turn it over to my colleague from Texas. Texas, the home of excellent high school football, mediocre professional football, and completely overrated barbecue.
Those are fighting words. Those are fighting words.
I'm not supposed to tick off that much of our client base. Rufino, over to you.
Well, thank you, Paul. Thanks for the introduction. It was very heartfelt. So, as Paul mentioned, one of the issues that I want to talk about today is the NLRA. And as you can see from this first slide, part of the reason I'm highlighting this is because despite how long the NLRA has been around, it's been around for decades, there are still employers, including some of our clients, who will remain unnamed, who still occasionally trigger potential violations of the Act. And so one of the things that is very easy to remember about the NLRA is that it applies to all employers engaged in interstate commerce. So it doesn't matter how many employees you have. If you are selling trinkets and you are even tangentially connected to interstate commerce, you are covered by the Act. And the other is that the NLRA's protections do not depend on whether your employees or your workforces are unionized. They apply across the board, and there are certain protections that go along with that coverage. So on this slide, you see the 3 main categories of protections: the right to form a union, the right to engage in protected concerted activities, or PCAs as they're usually referred to in the regions, and then the right to refrain from engaging in all of those activities. For our clients, for employers, the main issues typically arise under the second bucket, and that is employees who are engaging in concerted activities, usually for mutual benefit of themselves and their coworkers. So one example that continues to be problematic across the board is employees being disciplined over discussions with coworkers about their wages. That is protected concerted activity. There is no exception to that unless you're talking about legitimate supervisors. Any rank and file employee has the right to discuss his or her wages with coworkers, and any form of discipline against that employee is going to constitute an unfair labor practice. We still see that a lot. It's one of the more common problems that we see that is easily fixed. But there are also other things like engaging in discussions about workplace safety with other coworkers. And sometimes even if the employee is bringing a concern to his or her employer directly and not necessarily on behalf of others, the fact that the policy or the issue that the employee is addressing affects more than him or herself also could potentially make that activity protected as well. And then the right to refrain from engaging in those activities is essentially you can participate, you can choose not to participate. We rarely see charges under that section of the Act's protections. They typically would involve claims against union officials who are maybe intimidating employees. And there are rare occasions where an employer is trying to force employees' hands into either engaging in union opposition or union support as well. So that would also be covered and potentially unlawful. So the next issue here is really, I wanted to highlight where the policy priorities come from at the National Labor Relations Board, and they come directly from the General Counsel. The General Counsel currently is Jennifer Abruzzo, and she previously worked with the Communication Workers of America. Her policy priorities, as you might guess just from her union background, are to be very employee friendly. And I included here a quote. This is from one of the guidance memos that she issued earlier this year, in which she's essentially telegraphing to employers that she is going to use every opportunity that the Act provides to try to strengthen worker protections. And she has not disappointed. She has actually followed through on that promise. One of the issues, as in keeping with the theme of our presentation, is political speech. This quote that you see on the screen is from a speech that Jennifer Abruzzo gave at Cornell University earlier this year. And again, it telegraphs her expansive definition of what it means to engage in protected concerted activity. Certain things like protests, for example, had rarely ever been considered protected concerted activity. That was conduct that an employee was free to engage outside of the workplace, as long as the employee didn't violate any workplace rules. For example, did they obtain approval for time off to attend a protest? That was typically the extent of it. Under Jennifer Abruzzo's guidance, all of the regions are being instructed to pursue these sorts of issues. So what types of activities is she talking about? And is there really a nexus between that activity and the terms and conditions of employment? So Fight for 15, I think if everybody remembers, a few years back, there were big protests that were being organized by unions and other workplace rights groups pushing for $15 minimum wage. According to the General Counsel's current interpretation of the Act, an employee who goes and participates in a Fight for 15 protest or demonstration is engaging in protected concerted activity. I think there's an arguable basis that even though that issue relates specifically to wages for work, it doesn't actually relate to that particular employee's workplace, especially if it's somebody who already makes $15 an hour. So there's a real question there about whether there's a legitimate nexus to the employment and whether that activity should be protected under the Act. Same with immigrant rights protests. unless the employee, him or herself, is an immigrant or is advocating on behalf of other coworkers who are immigrants and trying to get lawful working status or something to that effect, there's not generally a nexus between somebody's immigrant status and their terms and conditions of employment. So again, there's a questionable nexus connection there. But Jennifer Abruzzo is continuing to push that idea. And the last one that I'll throw out there is Black Lives Matter, right? So you've seen protest demonstrations, buttons, T-shirts. A lot of you probably have policies that address dress code issues, like, you know, you can't wear any sort of political buttons or any clothing with logos, that sort of thing. That is a neutral policy. It does not favor one form of speech over another. Generally and historically, those types of policies have been lawful. Under this administration's priorities, however, those types of policies are coming under scrutiny. There was recently an example for a big retailer where an employee of the retailer was wearing a Black Lives Matter button on some work attire. The employee was asked to remove that button, and the region, when the employee refused to do that, he was terminated. The region issued a complaint against that employer. The case goes before an administrative law judge at the NLRB, and the judge ruled in favor of the employer, saying there is no nexus between how Black Lives Matter, which is a movement about how police treat unarmed Black citizens, and the working conditions of this particular individual. So because there was no nexus, the judge said that there could not be a violation if the termination was based on this employee wearing that button. The region has appealed that ruling, and so the case is going to be pending before the National Labor Relations Board. And so the final word has not yet been said, but it is coming. But I wanted to just, again, highlight that issue, because even if you win as the employer, one of the considerations that I always advise clients is think about the cost and the disruption of actually winning that case. And think about whether you had alternatives at the front end to address the situation differently so that you're not putting yourself at legal risk. So even though some of these political advocacy issues have not really gained a lot of traction in the courts and even within the NLRB itself, there is the possibility that they will, and you know, not to be cynical here, but I'm fairly certain that the NLRB is more likely than not to rule in favor of that employee in that Black Lives Matter case. It's just the way that it tends to shake out. It'll likely be a 3-2 vote. But again, we will know for certain soon enough. But again, the consideration for all of you is usually going to be more along the lines of, do you really want to expend resources on addressing those legal risks? And do you want to spend those resources on the front end to try to prevent them, or do it in the process of litigation? And that's really more of a business decision, as well as a cultural one for you as an employer. And with that, I'm going to turn it over back to Paul with some even harder stuff.
Thanks, Rufino. Yeah, so we're going to move a little bit from the purely or specifically employment-related speech to more of the general politics or politicians in the workplace. And why is it important if it isn't directly related to the workplace? Well, because we see in a recent SHRM poll, 56% of employees polled say that political discussions at work have become more and more common in the last 4 years. I don't think that's a surprise to anybody. 42% said they've experienced political disagreements in the workplace. 34% said that their workplace was not inclusive of differing views. And 12% claim that they've experienced political affiliation bias. Now, those are pretty big, or at least they're substantial. They're significant numbers. And so we need to think about it and look at it a little more. The good thing is there is good news for employers. For the most part, there's no blanket protection for political speech at work. Employers don't have to allow it or accommodate it. Oliver Wendell Holmes, famous Supreme Court judge, said, and it's a great quote, an employee may have a constitutional right to talk politics, but he doesn't have a constitutional right to a job. What a great quote for employment lawyers. I mean, that is A1 right there. Now, this was Justice Holmes, full disclosure. He made that in 1892, which is about 4 years before he assumed his role on the Supreme Court. But I won't tell if you won't, and it's a great employment lawyer's quote. So again, overall, there is no blanket protection for that kind of talk. Now, there are important exceptions. As Rufino just discussed, if communication, if political talk is directly related to the terms and conditions of employment, the right to organize, concerted activity of employees, et cetera, the NLRB is going to jump right in on that. And you certainly have to keep in mind state or municipal statutes or ordinances. There's a number of them. Some prohibit discrimination based on political activity outside of work. Fair enough. Some say that an employer can't take adverse action for expressing political views at work, so long as it doesn't materially interfere with job performance or disrupt the workplace. But all of these are nearly universal, that if it's causing significant disruption, you can limit it. So again, there are a number of states, specifically California, Illinois, Colorado, and Missouri. They have limitations on it, but again, it's nearly universal that if it's causing significant disruption, you can limit it in the workplace. A prime example of this is a recent Whole Foods case out of the First Circuit. Whole Foods had a dress code policy, said you can't wear slogans or political affiliation signs or buttons or anything like that at work. A group of employees wore Black Lives Matter masks and some pins and some T-shirts, things like that, and they received disciplinary points, which could have resulted in the denial of raises, denial of promotions, things like that. The employees claimed that that the policy was not universally enforced. And for instance, Whole Foods had allowed slogans and signs about the NRA, the National Rifle Association, or LGBTQ, things like that in the workplace. And so they were selectively enforcing their policy. And that was probably true. A group brought a class action claiming associational race discrimination under Title VII. And it was dismissed upon motion because Whole Foods treated, it was found, all the employees, Black employees, white employees, Hispanic employees, treated them all the same without regard to race. And the court said that at most, this was selective enforcement of political messages, which isn't protected under Title VII. So an interesting decision. Really, the court kind of, without citing him, they borrowed from Justice Holmes when they said an employee can always go someplace else to work or can make political affiliations outside of work. So an interesting case that supports the overall theory that for the most part, these aren't protected at work, political. So we know that generally employers can restrict it, but should. There are three approaches, from yes, restrict it all, to restrict some, to restrict nothing. And should they? You know, with great power comes great responsibility. And how will it impact the workplace? Well, option number one is obviously open season. Employers could allow political messages at work. Now, without regard to the message, what impact would that have? Well, it's potentially a positive public perception. This employer allows its employees to be politically active, but it's got potentially positive or negative employee morale issues. Could be potentially positive, obviously, allowing political discussion. But on the other hand, it could create great tension at work, depending on the particular workplace and how divisive that is. And obviously, whether it's positive or negative with morale, it's unproductive. Political discussion at work is taking away from the business of the company. So it's something to consider. It's one option. The next option, option 2, taking a neutral or positive political message and allowing those. So for instance, vote Biden or vote Trump. Those would be they would be positive political messages without being obscene or negative about any other. There are pros and cons to that. It's a middle ground. It's less divisive if it's just allowing positive political messages. But I'll suggest to you that the potential downside is in the administration. The employer is going to have to monitor what is neutral or positive as opposed to harassing or obscene kind of behavior. And it can get difficult. For instance, a MAGA hat, make America great again. On its face, it's a positive statement. Almost undoubtedly, people are going to say, but it has a connotation that has many negative messages in the workplace. This is a rhetorical question. We don't have to decide this today, but I think it highlights exactly what we're talking about. If you go the neutral or positive political messages allowed, you're going to have someone at the employer who's making the call, and it's going to be an administrative headache, if not an administrative nightmare. And finally, we've got the ban it all approach. You can say absolutely positively across the board, no political speech, no political buttons, no political T-shirts, things like that. It's going to be easier. It certainly will help create a neutral environment, but it's unclear what kind of effect that may have on morale in the workplace. There is a company, Basecamp, which was a software designer, may have read about it. They announced that they were going to have a complete ban on political discussion in the workplace, and within a few days, they lost 1/3 of its workforce. 1/3 of the employees resigned. Now, again, I think that's likely a very specific place, a very specific outcome, and they had about 60 employees, so it's a small sample size. But you have to realize that it may have some impact on the workplace. So again, here we can't tell you yes or no, right or wrong. There's no one size fits all. The message is that the employer does have options, and you've got at least 3 very different options that you can consider, and based on the particular workplace and the culture of that workplace, create a policy and a practice that's right for you. And that brings us, I think, to our first poll question. We've taken kind of a lighthearted approach. We'll ask you, which of these federal employment agencies do you want to deal with the least? And we've got the DOL, the EEOC, the the LMAO, the NLRB, OSHA, or all of the above. And it's a trick question because one of them is not an agency.
I bet you can't guess which one based on Paul's presentation.
Exactly. Give a second for everybody to vote. And by the way, if you like the lighthearted approach, some of the presenters may use it as actual substantive poll questions for you. While we're waiting for it, I'll tell you, if you like the lighthearted approach on this, think it's funny, I came up with it. If you're a little offended by the one in the middle, then in all honesty, it was Rufino's question. So. All right, just a few more seconds. We'll let the last votes come on in. Had I known we were going to have this time, I would have prepared a few jokes.
I'll ask you one, see if I can remember this. Why did the Scarecrow win the Nobel Prize?
I don't know. Why did the Scarecrow win the Nobel Prize?
Because he was outstanding in his field.
Nice. Very good. Very good. All right. I think we've got the numbers now. And I can't read them, so let me just grab them here. We got, 9.8 DOL, 24.2 EEOC, 6.4. I got to give a nod to the 6.4 for LMAO, 21.2 the NLRB, 9.1 of OSHA, and 28.5 don't like dealing with any of them. So well done. Well done. All right. Well, that moves us on to our next topic. We'll move to Hillary Klein. Hillary's going to talk about voting leave and voting rights among employees.
And Paul, you talked a little bit about dress code. I'm just curious, did you and Rufino talk about the dress code before today?
This is the official Husch Blackwell jacket.
I'm kind of wishing we could do another poll and ask who wore it best. All right. Well, I'm Hillary Klein. As Paul said, I'm going to talk with you about voting leave. We're heading into fall, and you're thinking pumpkin spice lattes and football, but you ought to also be thinking about what you do come election day with your employees. And I would suggest that you ought to be asking these questions, and I'm going to pose these questions to you. If you were in the room here, I'd ask you to raise your hand if you think the answer is yes. But just go ahead and think through on each one of these. Do you believe the answer is yes or no? First question is, do you have to give employees time off to vote? Yes or no? Do you have to pay employees when they're off to vote? Yes or no? What about notice? Do employees have to give you notice of their need to be off work to vote? And what about you as the employer? Do you have to give employees notice of their voting rights? If you were here in the room and you would raise your hands, I suspect that we'd have a mixture of answers. I suspect some of you would have raised your hand yes and said, yes, you have to give them leave. Yes, you have to pay them. Maybe yes or no on the other things. Others of you would have said, no, you don't have to do any of these things. And every one of you is right in some jurisdiction. The question is, are you right in your jurisdiction? So we're going to dig into each one of these questions a little bit deeper. And the first question is, do you have to give leave? Do you have to give employees time off to vote? Under federal law, it's easy. The answer is no. There's no federal mandate. Where you have to look at the law is under state laws and under your local ordinances. I'm going to focus mostly on state law here. So many states do have some sort of voting leave requirements. And just to kind of give you a sampling of what those look like, I'm going to talk about 3 different A states, beginning of the alphabet. So Arkansas is an example of a state that does have voting leave requirements. But under Arkansas law, the requirement is just that you schedule employees in such a way that they have time to vote. There's no specific hour requirement and nothing more than what I just said. In Alabama, you have to give employees 1 hour off to vote unless that employee's shift starts at least 2 hours after the polls open, or their shift ends at least 1 hour before the polls close. I'll tell you, that's a pretty common approach in many of these states where there is a voting leave requirement. There's some sort of an exception if the employee has some time available before or after their shift to vote. Yet another example is Arizona. So in Arizona, you have to give an employee time off to vote if they don't have at least 3 consecutive hours available before the start of their shift or at the end of their shift, or excuse me, after the end of their shift to vote. Now, Arizona is a little bit different, though, than what we talked about in Alabama. Of course, the hours are different, but also in Arizona, the law specifically provides that the employer only has to give the employee the amount of time that would total with the time that they have either before or after their shift, 3 consecutive hours. So let's take Sally, for example. Let's say Sally works a 12-hour shift, 7 to 7. Let's say that the polls open at 6 o'clock in the morning in Arizona. So Sally had 1 hour available to her before her shift started to vote. So the employer would have to give Sally in that scenario 2 additional hours at the start of her shift to vote. So you can kind of see from these 3 A-state examples that there's really a variance among the states that do have leave laws as to what they require and sort of what you can do in terms of taking credit for time that they might have available before or after their shift. Another example is Kentucky. So Kentucky requires that employees be given at least 4 hours of time to vote. And interestingly, in Kentucky, the law states that the employee be given 4 hours to go down to the clerk's office to register or to sign up, to fill out an application and cast an absentee ballot. And so, you think of, you've got the hours, the polling hours might be 7 to 7, but on a non-election day, if somebody's going to cast an absentee ballot, the hours might be more like 8 to 5, and so then they're limited in the hours that they can go to the clerk's office, and they're required to be given at least 4 hours. Kentucky also says that employees have to be given time off to serve as an election official and for training to serve as an election official. So I think the point here is just that all the states, or many states, have differing laws as to what is required for leave time to vote. And so you want to make sure that you look at those closely and understand the obligations, and then also check your local ordinances. So what about pay? We've talked about whether you have to give them time off to vote. What about pay? Do you have to pay them? Well, I bet you can guess the answer to this. The answer is, the favorite lawyer answer, it depends. It depends on the state that you're in. The majority of states that do require some sort of time away to vote also require that time away be paid. But remember, if we kind of think back to what's required in terms of time away, most of these states say you only have to give that time away if they don't have sufficient time to vote outside of their shift. So for most of your employees, they're probably going to have time to vote outside of their shift, and they're not going to be entitled to the leave to begin with. But if they are, they may be entitled to pay for that. So you'll need to look at that closely. And don't forget, with your salaried exempt employees, even if there's no obligation in your state to pay for leave time for employees to vote, you do not want to deduct from the pay of your salaried exempt employees. Most of the FLSA exemptions rely on employees being paid on a salary basis. And so if you deduct for things like employees taking time off to vote, you jeopardize that exempt status. What about notice? So notice requirements, as you can probably guess, they vary. They vary from state to state and locality to locality. The states that have notice requirements tend to be that the employee has to give a day notice. Where I live in Tennessee. In Tennessee, the employee just has to give the employer notice by noon the day before the election of their intent to take time off to vote. Other states will just say that the employee has to give reasonable notice of their need to take time off to vote. What about you as the employer? Do you have to provide notice? There are a handful of jurisdictions that require that you provide notice to employees of their voting leave rights. Not surprisingly, California and New York are among those jurisdictions. And in the places that do require it, it tends to be that you have to post some sort of notice 10 days before the election. So what if you're in a state that doesn't require notice? Should you still do it? A lot of folks would say yes. And there are a number of coalitions of employers that are trying to sort of increase the voter turnout that would say, yes, you should still provide notice to employees of their voting rights. And by the same token, you should consider allowing employees time off to vote and maybe even paying them, even if that's not required in your state. While polls are often open at times outside of somebody's shift and where they would have sufficient time to vote, we all know that life gets in the way and folks have commitments, family commitments, other commitments that oftentimes will make it difficult for them to vote outside of work. And so offering some sort of leave and even paying a little bit for that can help encourage employees to vote and also can maybe get you a little goodwill along the way. So if you're going to do that, how much should you give? It looks like most employers are giving about an hour to 2 hours. So again, that would be if you're in a state that doesn't require it, you might consider giving something like an hour or 2 hours of leave for folks to vote. A couple of other things that I'll just touch on. So one of the questions we get is, what about in these jurisdictions where you can engage in early voting? How does that work from a, do you have to give an employee time off to vote during the day if they have the opportunity to go to early voting? And the answer is that most jurisdictions have not addressed that question. And so I think you could make the argument in some jurisdictions that the employee has the ability to vote off duty hours and sufficient opportunity to do that. You could certainly make that argument, but again, the law is not clear cut on that. And then the other thing is, what if you have an employee that lives in Kansas, for example, and works in Missouri? Whose state law do you apply? You could consider applying the law of the state that's more generous. Probably the law that technically would apply would be the state where they work, but again, in an effort to ensure you're not doing anything that would be dissuading employees from voting, you might consider going with the law of the state that is the most generous in that regard. So just as kind of your takeaways, review your state and local voting laws well in advance of Election Day. November 8th will be here before you know it. As you're considering what you're going to do in that regard, consider both what the law says and also consider what the impact is going to be on your employee morale. All right, and with that, I will send it back to you, AJ, in the studio.
Thank you very much, Hillary. So now we're going to take our first break from the substance of today's presentations. The break should last about 10 minutes, so certainly feel free to step away if you need to. But if you stick around, we are going to be talking about a topic of some importance. And as I look at the title for my presentation, Falling for Autumn at Work, I'd like to think there's at least one person in my audience out there who has a crush on somebody named Autumn, and that person is now panicking that this presentation is targeted at them. But it's not. That's not what we're going to talk about. And actually, something else we're not going to talk about during our presentation is the fact that when I saw today's presentation date, I realized it was going to fall between my 10th anniversary at the firm and my 40th birthday next week. And so I went to our committee that sort of organizes these presentations, and I pitched to them that we use this break time to discuss, sort of my career and life accomplishments and do sort of a presentation on that, maybe bring in some guests, family, et cetera. And the committee said, absolutely not, rejected that idea completely, and actually told me not to mention either of those events at all. So I won't, right? And so instead, we're going to talk about something that is also of importance in September, in addition to my workplace anniversary and birthday, and that is the beginning of autumn. So we get a lot of feedback from our webinar attendees that they like sort of the legal advice we give them, the concepts, but they also like practical policies, information that they can put into effect in their workplaces right away. And so we're going to do that today. We're actually going to work through 3 model workplace policies that can help sort of manage the impact that fall or autumn can have on your workplace. The first thing we're going to deal with are fall cliches. And now the problem with fall, as opposed to other seasons, is that it tends to be a lot of people's favorite season. In fact, a survey of today's MCs demonstrates that it is the favorite of 100% all of today's MCs. The impact of that data, I think, is even more impactful when you see it in a pie chart, which I think also is more appropriate for fall because you're thinking about pies. So the problem is that when you have a season that people really enjoy, they're going to want to talk about it a lot. And that's when cliches can show up in your workplace. And there was an estimate that I just came up with that fall cliches and the time spent engaging in that banter cost companies billions of dollars every year. So what's our model policy look like? So all good policies start with an absolute, so no employee can use or display any of them more than, and then we do a limit that you can tailor to your workplace on how many times you're going to let them use the cliche. So let's talk about what cliches we recommend limiting. The first one, sweater weather. Yes, I get it. It's getting cooler outside. When it gets cooler, people want to wear sweaters. When we think about sweaters, we naturally think about Chris Evans in the movie Knives Out. Spoiler alert, he looked fantastic. But we can't spend all of our time sitting around thinking about sweaters and Chris Evans. We have to get some work done. So we do recommend that you limit how many times sweater weather can be discussed. Now, another weather-related limit that we like to put on there is the phrase feels like fall. You may hear this on a fall day. You might hear this on a cool summer day or a warm winter day. And we don't need to hear it, and we don't need to see it, right? Displaying the phrase can be just as distracting, particularly when you're wearing a short sleeve shirt, because if that shirt's accurate, if it really does feel like fall, she should be covering up with something like maybe a sweater. So in addition to weather, right, we have other cliches that we want to deal with. And that brings us to, I can't believe the leaves haven't changed yet, or any other statement expressing surprise over the fact that the leaves on the trees are still green and they haven't changed any other hue. Look, most of the times the people who say that are actually subtly bragging about having a window in their office. We don't need to hear it. And on top of that, you may want to actually have a policy that limits any foliage-related discussion, but we find, at least in our workplace, that foliage is so difficult to pronounce that it tends to sort of limit itself. So the next cliche is any reference to daylight savings time or falling back. It's a topic that lots of people like to talk about. Candidly, it's, in my opinion, pointless and confusing. Everybody has an opinion about it. My opinion is that it's pointless and confusing. And it's complicated, and it only happens for one day, but for some reason people feel the need to talk about it for weeks before and after. And because this is a national seminar and we have audience everywhere, some of you may be in a jurisdiction represented in red here that does not acknowledge or use daylight savings time. I'm talking to you in Hawaii, most of Arizona, some of the territorial islands of the United States. But you need this policy also. In fact, I have found that people in these areas talk about daylight savings time and the fact that their state doesn't do it way more than everybody else. Now, in your model policy, something to consider, right, is a reference or a carve out for talking about daylight savings for some number of days prior to the actual fallback. Because if you don't, this year it's on November 6th, you do risk that everyone shows up on Monday an hour early, and they will likely spend that entire hour talking about daylight savings time. The next cliche to limit is any reference to the old local football team. I'm talking high school, I'm talking college, I'm talking professional. During the fall, and Hillary actually mentioned it during her presentation, demonstrating that that's a real risk. People spend way too much time talking about football. It doesn't matter if the team is good or bad, they want to talk about it. So you have to have a limit, right? Here's an image of two generic football teams. We're not going to discuss either of them. Don't want to use any of my cliches that I'm allowed. Now, with this policy, right, some of these cliches, these are specific ones that we have focused on. Your workplace may be impacted by others. And so you're certainly welcome to sort of fill out a longer list. Before we turn to our next workplace policy, I do want to address one other sort of twist that you could put in your workplace if it works for you and your employees. And that is, some workplaces enjoy wasting time, right? They benefit from it. They see some value in it. Some of those workplaces encourage their employees to participate in time-wasting activities like fantasy football. And we can actually turn the fall cliches into a fantasy game as well, right? You take some time, you draft people within your workplace, and then you track how many times they use each of these cliches during the season, getting plus and minus points for the various things that they talk about, and then you crown your champion at the end. So again, just a twist if that's how you all want to roll with this. So what's our next policy going to be? So our next policy is on something that you really can't talk about fall without mentioning. Again, Hillary, without any indication for me that she should, mentioned pumpkin spice in her presentation earlier. Pumpkin spice and fall go hand in hand, and frankly, it gets a little bit much. So let's start with an important question, a definitional question. What is pumpkin spice? So most of you probably believed this. It actually contains no pumpkin, right? So policy limiting the use of pumpkin spice is not based on some humane treatment of pumpkins or anything like that, right? There's no pumpkin in pumpkin spice. Instead, pumpkin spice is a blend of spices. We've got cinnamon, nutmeg, ginger, cloves, and sometimes allspice, which I understand to be a combination of all of the spices, which I don't understand why you still call it pumpkin spice once allspice is in there, but that's a discussion for another day. Pumpkin spice is called pumpkin spice because we commonly use it to flavor pumpkin pie, but can also be used to season foods in general. And that's the problem, right? During the fall, pumpkin spice now shows up everywhere. So we do recommend a policy that limits not just discussing it, but possessing it, consuming it, referencing it in any way, or referencing or consuming or discussing any products that contain it. And then we do have some exceptions where we will allow it to happen. And here are those exceptions. we've got to have a window of time, right? When is it appropriate to consume and discuss pumpkin spice? So I did a little research when we were building out our policy here, and I used something called Google Trends. And so you can see Google Trends, pumpkin spice, 2004 to present, and it is very obviously a periodic autumn-based item. Now you'll notice there was a real spike in the sort of the middle here, right around 2017, 2018. It'd actually be much more appropriate if I were doing this presentation then, but we're still seeing a pretty big jump here in 2022. That's that blue line all the way to the right. That looks very much like a very unhealthy EKG as well. So let's take a look at the last 12 months. When do we want to start sort of pumpkin spice season within our workplace? So you'll notice this is just the last 12 months. So we see the tail end of last pumpkin spice season, and then we see the beginning of this pumpkin spice season. So where did things start to go wrong or right or up, depending on your perspective? The answer is July 24th. Under no definition, under no policy that any company would ever consider putting in place, are we going to let people start talking about and consuming pumpkin spice on July 24th? That's outrageous. And this is proof that more employers need this policy. We've got to get this under control. But what about where it ends? So you'll notice there's a little bump, right? There's a steady decline that takes place, and then there's a little bump, and that little bump takes place right at, as I'm sure you all guessed, Turkey Day, which is perhaps a cliche that your company would want to knock out on the other policy. But Turkey Day is sort of the last breath of pumpkin spice. We do get a little bit of a bump at Christmas, probably when people are saying things like, hey, do you want to eat the last of this pumpkin spice? Or how long have you had this pumpkin spice, creamer in the fridge? Those sorts of things. So we recommend, again, sort of setting up a timeline. We use a standard sort of beginning of fall, beginning of winter, so roughly the end of September, end of December. Your employer can come up with whatever is appropriate for your employees. And then we also want to put a weather-related limit on it, right? If you're dealing with hot summer days, but they're happening in fall, if it's warm outside, we don't need to be talking about pumpkin spice. We don't need to be consuming it at work, right? In fact, unless it feels like fall outside, we don't think that pumpkin spice belongs in our workplace. Now, some of you are probably thinking, didn't you just tell us we shouldn't even be talking about feels like fall? Yes, you're correct. But these wouldn't be model workplace policies without a little bit of hypocrisy baked into them. Plus, we do a geography-related limit on the weather because obviously feels like fall is going to be different everywhere. Some places that have beaches and oceans also have falls, or so I'm told. The last piece of our pumpkin spice model policy is a limit on what products we can actually bring into the workplace that has these things. So, for example, you can build it out, but pumpkin spice lattes make sense. Cocoa, that's a fall product anyway, right? Coconut milk, in case you are in one of those island locations. We got Oreos, those look delicious. We have Pringles, starting to get a little worried. We have cup of noodles. I would try it once, but never at work. Spam. Now, I got nervous about this, but I think the limited edition there on the Spam is a pretty clear indicator that this is actually intended to be more of a collector's item and not actually consumed by human beings. I think this one, Chipotle burrito, I'm pretty sure this is fake, but if not, you might want to include it on your list. You may not. I really hope that the pumpkin spice crest is not real. But if it is, again, something you may want to limit because people certainly do. People who care about dental health are brushing at work. So that leads us to the end of our first break in our first two model policies. After this next presentation, I will return to discuss a third model workplace policy to help control the impact of fall on your workplace. But before we do that, we're going to send it to our next set of speakers to talk about remote work. And so with that, to Sunny, Eric, and Ann, over to you in the studio.
Thank you, AJ. I really appreciate you helping us and our clients spend some time learning about what a critically important topic, removing cliches from the workplace is. I can always count on you to leave it all in the field, give 110%. That guy, AJ, he's just all heart, and we really appreciate him. As AJ mentioned, our next topic is going to be the top 10 questions employers are or should be asking about remote work. I'm joined by my colleagues, Sunny Nolan and Ann Mayette. Before we jump into our substance, we're going to start with a poll question. So if you could please take a look at the poll question and vote. Please indicate your company's return to work plan. do you mind clicking us forward on our screen?
There we go. Sorry.
Requiring all employees to be back full-time, being in the office full-time for some employees, but allowing flexibility for others, having a hybrid opportunity for all employees, or going fully remote for all employees. What our hope is here is that this can be an opportunity for you all to get a sense for what the rest of the group here, what the rest of the world is doing. I anticipate we're going to see sort of some numbers across the board, but please go ahead and select the option that best fits your business.
I feel like Jeopardy music should be playing right now. Like,
Right. We'll wait a couple additional minutes here while some of the results come in. As an aside, Husch Blackwell is probably in all of the above on these. We've got folks who are in the office 5 days, just as they were before COVID. We've got some people who are in the link, totally remote. So the real answer, of course, is going to be that it's going to be what fits best for your business.
I think the three of us have different, right? I think
Yes.
link and hybrid. Yeah.
Yeah.
So the
Yeah.
three of us are doing,
So we have our results. 15%-ish require all employees to be back in the office. About 50% having full-time for some, but flexibility for others. About 30% hybrid for all employees. And then only about 5% are fully remote for all employees. So hope that was interesting to you. Again, I think that's fairly consistent with what we're seeing. So with that, we're going to jump into the substance of our presentation here. And I'm going to turn it over to Sunny. And Sunny, I'll let you introduce yourself to the group.
perfect. Welcome back. It's nice to sort of see everybody again in this year's national program. We thought work from home would be a good topic to cover again, even though we're, not dealing with COVID as much, even though COVID is still around. But because the foundation for a lot of work from home programs, it wasn't really built because of the speed that people were going back to, or not to work from home or back to the office, we thought it would be a good time to revisit work from home to make sure that people are building the foundation. I'd say the first thing that people were really concerned about was time theft, that people were just going to be watching soap operas and they were not going to actually be getting their work done. And that really was the number one for a long time. However, this particular question, what special considerations regarding employee timekeeping should you be aware of? I would say off-the-clock work is actually more important than time theft, at least from a defense lawyer standpoint. Wage and hour lawsuits are alive and well, and employers don't have really good methods and policies to make sure that their employees are taking their breaks, that they are not working overtime, and things of that nature. In addition, because people are so mobile, you can move from Missouri to California and have very different obligations related to timekeeping. Bottom line, the past policies, procedures, and methods just aren't going to work. Everyone really does. If you're going the hybrid route, if you're going, the work from home route, you absolutely need written policies and procedures that are communicated and enforced. To ensure that you have, a lot of people have policies in place. I give you that. However, you need to ask these questions. If someone comes knocking at your door, plaintiff's lawyer in California, for example, we get that knock quite a bit. Are you going to be able to show the records that your employees took their required breaks under state law? Are you going to have the records to show that, in fact, someone worked overtime and didn't put in for it because they were trying to meet the productivity standards? If you can't answer those questions, if you don't have records for that, you're going to be in trouble. Because as everyone knows, all the employee has to say is, I never got my break. Oh, I worked, extra every single day. And that then the employer has to come up with the records to prove otherwise. So it's really critical. It's critical that you have in your policy that the employee must notify you if they choose to work somewhere else. There is no grace period. So if an employee goes from Missouri to California and doesn't tell you, you are still obligated to follow California law. California doesn't care that you didn't know. California wants the employee to be paid under their laws. And that is the same for lots of other states. So I really highly recommend that even though you probably already have a policy in place of some sort, that you need to go back and ask your questions, ask some of these questions, make sure the answer is yes overall. So that's topic one.
Great.
Now, I think I've scared everybody on following different state laws. So we'll get a little deeper into that. Anne?
Yeah, absolutely. So Sunny talked a little bit about keeping track of employees so that you have those records to when the plaintiff's lawyer comes knocking, you know, how did they work? So I guess the next logical follow-up question to that is, are there any rules or laws that limit the ability to track those remote employees' activities? Short answer is that yes, you can track your employees' activities or productivity if there's a valid business reason for it. The type of tracking that we've been seeing is keystroke tracking when people are actively using their computer, monitoring websites, applications on the computers, even recording video conferences, telephone calls. Those are the kinds that we're seeing. And so what we need to consider really then at that point is the state and federal laws that apply. There really isn't a federal law per se that applies. It's a lot of state laws that will require employers to give advance notice that you're monitoring your employees. And in a lot of cases, the best practice is to also obtain consent. So the state laws require you for their personal privacy to give them advance notice, but to further protect yourself, get that consent from the employees. And so the kinds of things that you would be, monitoring are emails and things like that. But the big caution that I want to give most employers on this is the real distinction between personal versus company equipment. When you have these remote employees, you have instances where the employees are using sometimes their own personal equipment at home, a cell phone, even in some cases a computer. And I think we'll talk about that a little bit later when we talk about expense reimbursements, a little teaser there for you. But the employees do have an expectation of privacy with their personal equipment. So when there is an intermix between the two, employers need to be really careful to ensure that they are not monitoring anything personal that's on an employee's device because they have an expectation of privacy with that equipment. So what's really key here is to have a policy, have it all in writing, have a policy so that the employees know exactly what's being monitored, when it's being monitored, why it's being monitored, so that there's no confusion, there's no surprise on the employee's end. And so really having that very clear policy is going to be the key here. The one last thing that I do also want to make note of, because I mentioned it, is recording. We do have some states that have wiretapping laws that will prevent employers from recording video conferences or phone calls without getting their employee consent. And me being from Illinois, I am very attuned to biometric privacy laws. And so there are an increasing number of states that are restricting the use of biometric information, for example, fingerprints to log into a computer, facial scan to log into a computer. So getting a policy and consent in place for collection of biometric information. So you need to be aware of that too. So in the end, really, you can track your employees and you can track their productivity, but you need to be aware of those state laws. You should have a written policy in place, give that notice and give that consent. And so next I'm going to turn it over to you, Eric. Now that we've kind of explored whether employers can legally track their employees across the country, how do we determine what tax laws apply for all these employees that are now working across the country?
That's a great question, Anne. It's one that we're getting a lot already, and I suspect many of you out in the audience have been struggling with. Let me start by saying I fully acknowledge that there is way more text on this slide than would typically be recommended. But my panelists made the joke yesterday that it's actually appropriate because the tax code in and of itself is sort of an inaccessible behemoth. So I'm okay with the fact that there's a lot of text here. The short answer to Ann's question and the question about how I determine which tax laws apply is it will depend on where the employee is working and where he or she are performing services. Some states, about half of the states, a little less than half, have reciprocity agreements in place. So I'm sitting here today in Kansas City. There's a reciprocity agreement between Kansas and Missouri, which allows an employee to permit withholding in only one of those states, pay income tax in only one of those states. But again, less than half of states have that sort of rule in place. And so if you don't have a reciprocity agreement and you're trying to analyze where or which law would apply, there is a fairly complex set of laws and regulations that provide a framework that outlines how long an employee can be temporarily present in a state for work purposes before the employer is required to make some kind of withholding for income tax. And there's a formula that differs state by state, which takes into consideration the number of days an individual is in that state, how much they're earning, or some combination of those two factors. Now, becoming liable for those sort of tax withholding things is not just a problem for the employee, but it can also be a problem for the employer. Because as you can imagine, if the employer fails to properly make those withholdings, the state can typically collect that tax from the employer if they make a mistake as well. Now, during COVID, over the last couple of years, a number of states suspended these sort of temporary presence rules. They said, listen, we understand that there might be people who are going to be traveling and working in different states because of the circumstances of their personal lives, and so we're going to not enforce these rules. As of today, most of those measures have expired. So we're back under the same legal regime where we're needing to track if an employee is going to be present in another state to determine when our obligations kick in. So if we determine that, yes, in fact, we do have to do that analysis. If you've got an employee in another state that you haven't previously worked before, there are obligations that you and your in-house benefits and accounting team are going to have to work through. There are state corporate or other business activity taxes that may apply, and they may apply even if you only have a single employee in that state. There may be an obligation to register with the Secretary of State or notify the relevant tax authorities to provide things like a registered agent address, and then go through some of these other employee obligations. We have fielded a number of calls over the last months or years where employers are asking us about this after the fact, after they've already had the employee who's been working in that other state. Because states aren't typically going to notice this. This doesn't pop up on the radar screen of a state taxing authority necessarily. So the way that this typically comes to a business's attention or to our attention is you may have an employee working in that state, a remote employee working in a state where you haven't been before, and she, after she is terminated or laid off, files for unemployment compensation. Or maybe she becomes aware that she's in a state that now has a very generous paid family leave law, which is different than the one in the home state of the business. So she files a claim for benefits or she files a complaint of some kind. The agency becomes aware, they look in their records and they say, oh, ABC Corporation hasn't ever registered to be an operating company in this state. They contact the employer. We're now down the track of an administrative agency audit, and the employer can be exposed to different investigations, audits, and fines. Big picture takeaway, this is an area that is complex, probably even above the pay grade of us mere labor and employment lawyers, but we have excellent tax colleagues and benefits colleagues that we often work on this. My takeaway for you is, when you are hiring even a single employee in a different state, you should do your diligence to understand whether that's going to create any of these additional obligations. In addition to the tax obligations, and you guys have alluded to this before, there may be some additional monetary obligations that you have in some other states. So I'm going to go back to you, Ann, to ask the question, am I required to reimburse remote employees for some or all expenses?
Thank you so much, Eric. That is a great question and one that we have been fielding for a lot and for quite a long time. So the short answer is it's a state-specific question on whether you need to reimburse employees for necessary business expenses. Federal law only says that you need to make sure that you're paying your employees minimum wage. The expense reimbursements are really determined by the state law. So just to name a few, and I don't think you're going to be surprised here, California, Illinois, New York, Washington, D.C., a few kind of other surprises. We've got Montana, Massachusetts, do require employers to reimburse employees for necessary business expenses that they have incurred in order to do their job. And so really then the question becomes, now that we have all these remote employees, what are those necessary business expenses that they are incurring in order to do their job? So some of the ones that you're going to see are cell phone, reimbursement for a personal cell phone, for the data plan for the cell phone, internet, home internet, and in some cases, home office setup, such as a printer, shredder, office supplies. Those are the kind of items that we are seeing questions about. In some cases, you'll even see requests for reimbursement for an entire home office setup. And whether you really need to reimburse for those items comes down to the state law and is whether it is necessary for the employee to do that job. So you really need to take a really fact-specific look on whether you need to reimburse according to the state law and whether it is necessary for the employee to do that. And what really it comes down to for most of these laws is that you're going to need a very clear written expense reimbursement policy. That will help avoid any issues as to what can be reimbursed, how the employee should seek reimbursement, and you should include things in there such as advance approval, documentation, time limits on when they can submit for reimbursement. Some of these things are even included in these state laws. And so, for example, I'll go back to Illinois. It's very important to have a written policy in Illinois because if you have this written policy and the employee doesn't follow it, the law in Illinois says that you are not required to reimburse them. So it's very important to have this all laid out. And what, besides the fact that we do have legal implications, the one thing that I do really want to touch on is the employee morale implications of expense reimbursement policies. So while, yes, some of the employees that you have working remotely in other states will need to be reimbursed, consider the employee morale implications in states where maybe those laws don't exist. There have been a lot of polls where employees feel as if it's a pay cut, that their salary has been reduced if they are required to, come up with these things in order to perform their job and pay for them themselves. And there have been a lot of studies that are saying that employees who do receive some sort of reimbursement for at-home work products, they actually turn out a better work product because they're not thinking about ways in order to get around doing their job in order to save expenses. So that's really one of the big things that I want to have as a takeaway here. So yes, in some states, you're going to need to reimburse these necessary business expenses, but thinking about it as an overall policy for the company and considering your employee morale with the remote employees that you have. And so next, I want to take it back to Eric to talk about whether, after we've talked about reimbursing employees, what do we need to do if we've reimbursed this home office setup to ensure that it's safe?
You've paid for the fancy new office setup. You've got the desk that raises and lowers. You got that squishy mat for your employees to step on. You've got the high-speed printer, all of that stuff. What must you do in addition to ensure that your employees' workplaces are safe? And I guess even a threshold question. Once I've paid for that and once an employee is working at home, do I even have an obligation to ensure that that workplace is safe? Well, it probably won't surprise you to learn that the answer is yes. You do have some obligation. And so we start by taking a look at sort of what the legal framework here is. The Occupational Safety and Health Act, the federal law that applies to workplace safety in most workplaces in the United States, also can or does apply to a home workplace, because the Act by its terms applies to work performed by an employee in any workplace in the United States, even a workplace located in that employee's home. The next bullet point that I've got is some language right from OSHA's website. Even when the workplace is in a designated area in an employee's home, the employer retains some degree of control over the conditions of that work at home agreement. It's an important factor in the development of those arrangements to ensure that employees are not exposed to reasonably foreseeable hazards created by that employment. And so what OSHA says is that there are some circumstances where that quote unquote exercise of reasonable diligence, which is what the obligation of the employer is, would require an on-site examination of that working environment. I don't want you to get too freaked out about that. I think it's fairly rare where you as an employer would have an obligation to go on-site and ensure that the remote work site for all of your employees is safe. But it probably is a good idea to provide all employees who are going to be working remotely some sort of checklist to ensure that they've got a safe system, that there aren't electrical hazards, that there aren't trip hazards. I've got ergonomic considerations identified here, right? I mean, there's all sorts of data that suggests that if we ensure that, we have a comfortable place to sit, that the computer monitor is at an appropriate height, that we're able to sort of stand up and take breaks when we need to, that's going to lower the risk of repetitive injuries and other things that could lead to claims. And then the final bullet point that I have here that I wanted to mention is this idea of stress and mental health. We think about that also in the context of safety. Good recommendations are to have employees create a dedicated workspace in their home to allow them to focus on tasks free from distractions like kids or dogs or fantasy football. For remote employees, encourage them to take regular breaks, to take a lunch break, to maintain regular hours. I certainly felt over the last couple of years, as I was doing more work from home, that my workday just kind of expanded. And it started as soon as I woke up, and it didn't end until I went to bed, because there was always the computer there with messages to respond to. But if we're thinking about keeping a sustainable workplace environment, it's a good idea to encourage employees to still maintain that schedule. And then finally, on a recommendation we have is to encourage managers to find time for the sort of casual conversations with remote employees as a replacement for the conversations that might happen over the coffee machine or the water cooler. That's an important thing for individuals' mental health. Speaking of mental health, I think the next question is about remote work as an accommodation. Sunny, talk to us a little bit about that.
Absolutely. And because I could go on all day, I will absolutely make sure that I don't, because I feel like we all love these topics so much that we may have gone over a little bit. So I don't want to rush this part, but everybody's working on accommodations all the time. But work from home is just a new animal in many ways, and there hasn't been a lot of guidance. However, I think we're going to start seeing a lot of guidance because the EEOC just filed its first lawsuit on work from home. So we should start seeing some more guidance around that. The EEOC's lawsuit actually predates COVID, so it's under different circumstances, but I think we'll get some guidance there. The other thing recently the EEOC has done, they filed 3 accommodation lawsuits against 3 very large employers. So it does seem like accommodation, work from home is really on their radar. Like every other accommodation request, that case-by-case analysis still applies. Even though there may have been a history of someone else couldn't work from home or what have you, it is so critical to take the time to look at the individual and their job as it exists at that time, and make sure that you're going through that interactive process. Speaking of the interactive process, please document it. You're all very busy. And when, a year from now, we get a lawsuit, you're like, I don't remember, what happened first or what documentation I got. Please, it's so critical that you do and keep it separate, but document the interactive process because you're going to get a lot of questions and they are going to get conflated. Past work from home, just like any other accommodation, it's a trial period. So you're not stuck forever in a work from home situation or any other accommodation, but it's really critical at the beginning. If you do give that accommodation, make sure that the employee knows that it is temporary. In-person work, we have regularly for years said that that was an essential function. It's going to be harder for us to say it's an essential function when someone has worked successfully from home for 2 years. So that will be scrutinized more than ever, and job descriptions will really help you in this area. Collaboration, in-person training, things like that. Putting that in the job description will be helpful to show. It is one of the factors that the courts look at and the EEOC look at when determining whether or not it's an essential function. Finally, equal treatment is so critical. I know we have the great employee who we want to bend over backwards for because they do, and the not so great, and we don't want to necessarily have them work from home, but you really just have to give corrective action for not doing the job. Don't punish employees by not giving them the accommodation that they might need. So those are a couple things to just keep in mind. This really is foremost. And then of course, timely document performance issues. I can't tell you how many times where it's like, well, but they've had this problem for a year. And I'm like, well, but you didn't write it down at all. So really critical, take the time to write all of that down. Speaking of working from home and being ill potentially. Oh, and one other last thing I'll say. Anxiety is a really big one right now, and Eric mentioned that. There is a lawsuit right now where an employee gave 2 different reasons for work from home. The third reason was anxiety. And, the employer was a little suspicious, but bottom line, you still have to go through the interactive process. Anxiety is something that you do have to accommodate. So, Anne?
Thank you, Sunny. And so, following from that, I think we need to talk about again whether we need to revise our company's policies on sick leave, paid time off. I think the biggest question now that we've got remote workers is, do you have new paid leave obligations? Have you had employees that have moved out of state and they are in a state now that has sick leave laws, paid sick leave laws, different regulations for paid time off, paying it out upon termination. So I think that's the biggest consideration you need to be looking at. Where are your employees located? And do you have new obligations for these employees in those states? I think kind of going off of that, and I'll skip ahead a little bit here in my slide, are there COVID-19 related laws out there for sick leave that are still in place? I know that there are. And so looking at the locations where your employees are to see if there are paid leave requirements for COVID-19 and ensuring that those are in your policy and your policy is updated to include that. Even having a separate COVID-19 leave policy, it may go away, it may not. I think time has shown us, we just don't know. And so, having that policy in place. And then I think a really big one here is making sure that your policy is clear on leave reporting and tracking. You have these remote employees at home. We've talked a little bit about, time theft, off the clock work. Where are they? What are they doing? Are they working remotely, but also now working while they're, on a boat in the Caribbean where we would all like to be. And they, have said that they're on vacation. So it's really important to revise those policies to ensure that you have clear reporting, clear tracking. This is going to be important, in states where you have to pay out earned but unused vacation time at the end of employment to have those records. So employees need to know how they should be reporting that. And so, I will now kick it on off over to Sunny, and we can talk about new obligations under equal pay.
So the answer to the question on assuming, more obligations under pay transparency, yes. If someone moves into a state, you are potentially going to be obligated by that state's pay transparency laws. There's about 20 states, I think now, that require pay transparency. And so that's just one of those, additional things that as national employers, you're going to have to manage that. One way that to avoid especially pay equity issues is right now doing an analysis on how you make your pay decisions, coming up with a strategic pay philosophy. And there are lots of factors that go into doing that, but that's really critical. And the reason it's so critical, it's because then you can have a consistent approach. But until you have that policy, until you have that strategic, pay philosophy, it really is difficult to have that consistent approach. And I will tell you, as on pay adjustment, when someone moves from New York to, St. Louis, Missouri, are you going to really lower that person's pay? Are you going to be consistent, when it's not someone who's doing so well? So when you have that policy in place, it makes those decisions so much easier. The other thing is just making sure that you are calibrating the pay reductions, that you're looking at market rates. I got to tell you, a lot of people don't think they pay for geography or market, but when they really start to analyze how they're paying their employees, that is a hidden factor that they ferret out. So I really think this is the time, and you can do it with your lawyers for sure, just to make sure that it does remain confidential so you can take the actions that are appropriate. There's a lot that's going on right now with pay equity. So this is a really good time to be proactive. I know sometimes that's difficult, but this is the time to do that. So with that.
Good segue, Sunny, on the issue of confidentiality. We're going to do the next two kind of together, Ann and I. I'm going to first talk a little bit about restrictive covenants, so confidentiality, non-compete, non-solicitation agreements, and then Ann's going to talk a bit about sort of things that you can do as an employer to ensure that your business's confidential information is protected. So very quickly, this issue of non-competes, restrictive covenants has become, I think, a salient issue now because there are some that ask the question, are remote employees at a higher risk? Are they more likely to, take confidential information? Are they more likely to go to another employer? All relevant questions. And so what I want to just highlight here is that there has been a lot of activity recently here from a legislation standpoint, an increase in employee-friendly laws that relate to non-competes and non-solicitations. You see, we've got states like Washington, D.C., California, North Dakota, and Oklahoma, which effectively ban these kinds of agreements with limited exceptions. Illinois, Nevada, and Virginia that have passed laws prohibiting enforcement against sort of low-wage or hourly workers, and other states like Colorado and Oregon that permit it, but only in certain instances. So my takeaway for you here is to really consider the choice of law that you might have in that agreement. If I'm a Wisconsin employer that have historically only had employees in Wisconsin, I haven't really had to think about it. But if I'm now going to have employees in Illinois, Minnesota, Iowa, do I want to think about whether I need to change that law to permit enforcement against an employee in one of those other states? So if that's what I'm looking at for my employees, Ann, what should I be thinking about in terms of taking steps to protect the business's confidential information?
Yeah, exactly. With the advent of remote work, you have employees at home with your confidential information, your trade secrets. It is not confined necessarily physically to the office space like we would traditionally think about it. So some of the things that we can do, confidentiality agreements, which you would often see when the employee starts work, entering into that confidentiality agreement, limiting the access to information that employees have on a need-to-know basis. That would be important. I think this kind of goes hand in hand with some of the stuff that we've talked about before, is having that separate space, ensuring employees have a private space to work when they're working remotely. You don't have, your husband or your dog reading that trade secret, behind you. Those kind of things. Making sure really overall that you are identifying what's confidential information and marking it confidential, ensuring that the employees understand their obligations for it, and even going so far as to prohibiting access sometimes to that information if the employee has it on their personal device, and prohibiting it. So, and then I think lastly, really, and I think this is where we see it a lot, is reminding employees of those confidentiality prohibitions and obligations at the end of their employment. So.
Terrific. Well, if you're counting at home, you would have said, that's 10. You told us you're giving us top 10 questions. We're giving you a bonus question here to close out. the number 11, what strategies can I use to keep my remote employees engaged and connected? This is maybe less of a legal question and more of a practical question, but it's probably front of mind for many of you. So here's just a couple quick things to focus on. The first one, this term proximity bias, which I had never heard before until the last couple months, but there's this interesting theory bubbling up now, which is to say you have to be careful not to give preference to those employees who happen to be in person versus those employees who you've authorized to work remotely, especially since we often see women who might be caregivers, other individuals who are caregivers, people of color who are predominantly make up a more remote workforce. You know, there's a risk that if you're giving preferential treatment, assignments, et cetera, to folks who are in the office, that you could be at risk of some sort of litigation claim. Focusing on employee onboarding, that process is harder to do remotely than it is in person. It takes extra effort. Keep remote meetings as short as possible. We were having a conversation in the green room about this, about, you know, how long do you really stay tuned in when you're on a Zoom meeting? Is it 10 minutes, 15 minutes? Hopefully you've been with us the whole time. And we talked a bit about recording meetings so that they can be accessible to people, ensuring that the resources that you use are available virtually. And then the final one, I've got that in the middle bullet, creating opportunities for both virtual and in-person social interaction. We as an employment team try to get together once or twice a year to have that in-person stuff, in addition to the monthly Zoom meetings and then our regular meetings that we have together. Those face-to-face times are really important for us building that team and keeping people engaged. So that's our top 10, really 11 questions. Yes. Thanks for your time. We're going to send it back to the Prince of Pumpkin Spice, AJ, to tell us a bit more about workplace policies.
Thank you so much, Eric. Prince of Pumpkin Spice is a title that I don't think ever needs to get used again. And for our next policy, we're diving back into managing the impact of fall on your workplace. We're going to talk about a holiday that occurs during the fall that is an important one in a lot of parts of the country, and that is, of course, Halloween. And really what we're going to do with this policy is acknowledge that in the workplace, you know, you gotta insert some HR into your Halloween management. Halloween uncontrolled is a real risk for employers. So, you know, some people refer to this time of year as spooky season. That's another cliche that you could consider eliminating from the policies we discussed earlier. And, you know, spooky season creates a lot of energy, a lot of excitement. It can be a lot of fun. You know, television shows in the workplace are famous for having, you know, Halloween-centered themes. But in reality, right, costumes and people wearing them to work can be very disruptive. So here's what we recommend. You know, a policy that addresses that no employee shall wear any costume, and this one's important, during work hours, that makes sense, while on company property, that makes sense, or near any person who has even the slightest understanding of where the employee works. Now, you may think that makes this policy a little bit too broad, right? We're going to be capturing a lot of activity, maybe some activity that's protected by the NLRA. I wasn't paying a lot of attention earlier. But I think it's also really important because your concern, right, is that a costume that one of your employees wears gets seen by someone who knows that they're your employee, and then we've got a whole bunch of trouble. So what are the exceptions to this? When will we allow them to wear a costume? So the first exception, or the first requirement, right, is that the costume would be inoffensive to my grandmother. Now, that's specifically my grandmother. That's who we built in as sort of the subjective determination of what is offensive or inoffensive. And so I think, you know, you can, within your own workplace, determine what that's going to be. And in order to give you a sense of what is offensive or inoffensive, I actually have several slides of offensive Halloween costumes to show you. Unfortunately, that same committee that reviewed and told me I couldn't talk about my work anniversary last week or my birthday next week, they actually reviewed and censored all of these slides. So you're not going to get sort of the full understanding of what an offensive Halloween costume is. You're going to have to sort of imagine that yourself. And so your employees are going to be sent then to the internet to Google things like Halloween costumes that are appropriate for work. And there are resources out there, most of which will bring you to things that would not offend my grandmother. But that's not enough, right? We don't just want people showing up in boring costumes. So we added some additional requirements. Not only does it need to be not offensive, but it also needs to be based on a delightful pun. So for example, and I'll give you a moment before I reveal to you what each of these are, you know, an option would be a ceiling fan. That's right. I'm going to sort of talk to you like I'm Dora right now. Or perhaps, yep, that's right, Smarty Pants. Or maybe It's really unfortunate, but that is a blessing in disguise. Or a breadwinner. That's one smart cookie. Or actually, it's lots of cookies. That's many cookies that are smart. I don't know, that one doesn't work as well. Or how about this one? Now, this one actually took me a little bit of time to come up with or identify what it is, because it's only showing one ingredient, which is the avocado. But I think this is supposed to be wholly guacamole. Now, if I were doing this, I would add in the other ingredients that go into guacamole. We don't have time to lay out that whole recipe now. That's something maybe we can address during the summer. But maybe not everybody wants to just do a costume that's a pun, right? So we do give them the option that it can either be a pun or it can be something that is specifically funny to people in an HR related, or specifically terrifying, I should say, to someone in an HR field. So what is a costume that actually scares you, HR professionals and employment lawyers? So here's one, right? This person is dressed up as it's a vague doctor's note, right? That's something that creates a lot of problem, a lot of fear for us. These are, of course, time thieves, something that scares any corporation. This is just a millennial, right? I think most of us in HR or HR-related fields are terrified of this person in our workforce. Here we've got social media, right? A big time waster, similar to the fantasy football that's been mentioned today. And then we've got somebody who just dresses as a red flag, right? And this one's actually customizable, right? So we've got somebody who complained about unsafe work conditions. That's a little bit scary. Maybe somebody recently took an FMLA leave, right? It's going to be a little nervous when you're taking an employment action there. Perhaps they regularly attend labor and employment seminars, so they are more informed about their rights than we would prefer our employees to be. And then, of course, you've got what can happen if you ignore those red flags. We've got somebody in the costume. This is a lawsuit with quite a few Benjamins tucked in that pocket. Another scary employment costume. We've got OSHA showing up at our door. Or perhaps we have misclassified, could be an independent contractor, maybe an exempt employee. And then just a scary clown, right? That's scary to anybody, but what makes it scary specifically for those of us in the HR-related fields is that balloon says open enrollment period, something else that happens during the fall that we probably would prefer not to have to talk about. And then finally, the scariest thing of all to employers when we're dealing with employment law, and that is the terrifying state of California. So hopefully these model policies, all three of them are things that you can use. Certainly, if you need me to send over a Word document so you can modify them, let me know. And certainly if you have any other policies you'd like us to discuss next time, please do mention those in the comments and in your survey. But that is the end of our second break. And so now we are going to send it to our last presentation of the day, which is about workplace safety. We're going to send it over to Tracy and Brian in the studio.
Thank you, AJ. My name is Brian Hendricks. I'm a partner in Husch Blackwell's Washington, D.C. office. And with me, I have...
I'm Tracy Wolf. I'm a partner in our Dallas office.
Today, we're going to discuss workplace violence, health and safety concerns, and gun laws. And right off the bat, I think we should say that we are opposed to workplace violence of any sort. We're peace-loving folks, lawyers though we may be. I think that's a fair thing to say.
Very much so, yes.
Very much so. So we're opposed. Just get that out of the way.
And violence, it's become a very common theme right now in our culture. We've heard a lot of terrible things, and I mean, it needs to be addressed. There's a lot of things that have happened across the nation, not just in the workplace. It extends well beyond the workplace. And the United States is the country with the most arms per capita in the world. And there are a lot of various political beliefs and a lot of belief systems on weapons, particularly firearms. And we're not here today to get into that. What we're here today to discuss is how workplaces and how employers can take preventative measures and what the actual facts are, and the fact that so much of this is legislated from state to state that it's often difficult to keep up, but we're going to do our best to give you an overview and to help you in making some of these difficult determinations as our society evolves.
Now, obviously, workplace violence and violence in general isn't new. As long as there have been humans, there's been violence, unfortunately. So this isn't a new topic. It's also not a topic that hasn't previously been addressed by both federal OSHA and the state plan states, the states themselves, in terms of occupational safety. But it's something that employment lawyers have been dealing with as long as there's been employers and lawyers. We see them all over. Our workplace violence occurs in a lot of different places. And at this point, I'm not sure when I first had active shooter training, but it's probably been more than a decade now. Even at a law firm, we had active shooter training. So it's become somewhat of a norm. Today, my daughter's elementary school is having a lockdown drill, which is what they call it. I think they called it a hibernation drill in preschool. So I think that overall the culture seems as though that violence, both in the workplace and in public, is a hot topic. It's something that we've all been hearing a lot about. However, if you'll go to the next slide there, it isn't. It's extremely rare. Random mass shootings are still extremely rare in most workplaces. Thankfully, violence of any sort is rare. However, homicide is a leading cause of occupational injuries, and shootings account for the majority of those homicides. Every year, OSHA says that there are 2 million workers that in this country are harmed or injured by workplace violence.
Yeah. It's still, you hear these numbers and they're staggering, but all in all, workplace violence is still sort of rare, but there's been an uptick, and this is something that draws the attention. The statistics truly are staggering.
I won't bore you too much with the numbers here, but when clients ask me about what OSHA is concerned about, these are the numbers that drive OSHA, the reporting and record keeping injuries and illnesses. And the numbers in the overall scheme of things, they jump out at you, 15 to 25,000 assaults. Now, fortunately, if you look at 2020, there were 20,500 injuries and 392 fatalities, homicides in the workplace. There were at least those were the fatalities that the Bureau of Labor Standards captured.
And you've got 304 of those are through shootings.
That's correct.
So that's a very high number.
You do see those focused in certain areas, in certain industries, and we'll cover that in just a second. Now, let's talk about what is workplace violence. How do we define it? Now, there are various definitions out there of what is workplace violence, and just so everyone knows, the photograph here is not a photograph of any Husch Blackwell attorney striking someone. It's not an action photo from a deposition. Close, but it's not actually what occurred. But in any case, this is OSHA's definition of workplace violence: any act or threat of physical violence, harassment, intimidation, or other threatening, disruptive behavior that occurs at the work site. I think it's important to remember here also that it is one of those, you know it when you see it. You have a threatening a pattern of behavior, threatening kind of attitude. All of those things are indicators potentially of actual physical violence. OSHA has been very clear to say, though, that it is not interested in, has no intention of including violence that is solely verbal. But OSHA is interested in threats that could reasonably be expected to result in violent acts. And I know that there's a difference here of opinion about whether there is solely verbal violence. I tend to go with the Chris Rock school of thought that anyone who believes that words can be violence hasn't been punched in the face. But I know that Tracy, for example, might disagree with that.
No, I do disagree, and I think that a lot of times the OSHA's views, I mean, they're very stringent and kind of directed, and I know Brian, of course, here is very much an OSHA specialist, not so much myself, but I will say litigation-wise and liability-wise, I think words cause every bit as much of an issue and can definitely incite violence.
They certainly create liability, without a doubt.
They do create liability.
Additionally, Niosh, which is the National Institute of Occupational Safety and Health, Niosh is, in essence, OSHA's research wing. Niosh has done a tremendous amount, and we'll cover this in just a second, tremendous amount of work on what constitutes violence, how to characterize the violence, and that's what we're looking at here. There are a couple of different, well, rather 4 types or categories of violence. One is the violence with criminal intent. This is your standard, an individual comes into a retail establishment to rob that retail establishment. Type 2, I want to focus on. This is customer, client, patient. The reason I want to focus on it is this is the type of violence that you normally see in the healthcare setting. That's the type of violence that accounts for a tremendous percentage of all of the workplace violent incidents that are reported every year. Something like 2/3 to 80% of all the violence in healthcare is this patient on healthcare provider type of violence. Third is worker on worker. And finally, personal relationships. OSHA is also cognizant of the fact that it's very difficult for an employer to have a policy or procedure to prepare for these personal relationship incidents or types of violence that are related to personal relationships, where a disgruntled person in a relationship shows up at the workplace to do harm to others in that workplace. That's a very difficult thing to deal with. Now, in terms of the OSHA's view on things, OSHA recognizes, as we all do, that there's potential for violence in every workplace, but the risks are higher in certain industries. And OSHA has focused all of its resources to date on these industries, which makes sense. All its educational enforcement resources, the guidance that it has produced, generally speaking, are focused on these specific industries. And they probably won't come as a surprise. Late night retail establishments, for example, the all-night 7-Eleven that's open. Taxi drivers. What did surprise me is that a taxi driver is 20 times more likely to be killed at work or on the job as compared to other employees.
Wow.
Yeah,
that is shocking.
Corrections officers, which makes a great deal of sense given the folks that they come into contact with frequently. What did surprise me was education. That is a source of a lot of occupational injuries related to workplace violence. Now, OSHA has not yet promulgated a workplace violence standard or regulation. But, as I said previously, there's been a tremendous amount of work done over a long period of time, I think starting in the 90s, basically, by OSHA and Niosh and various other organizations specific to workplace violence. So policies, procedures, checklists, that type of thing. They've published extensive, both industry-specific guidance and some general guidance that any employer can follow. Now, the fact that OSHA doesn't have a specific standard doesn't mean that those folks who are regulated by OSHA are off the hook from a regulatory standpoint, from an enforcement standpoint. OSHA has, and will continue to cite employers under the General Duty Clause for workplace-related violations. And OSHA is currently working on a workplace violence rule, a new regulation. It may be specific to healthcare. We will have to see. I know that there's a desire in the states. There is a desire, for example, in California. California is usually the leader or outlier, depending on your perspective, when it comes to developing new standards. California is likely to adopt a general workplace violence standard for all covered employers in the state of California. It currently has a workplace violence standard for or specific to healthcare, and several other state plan states. Now, these are states that federal OSHA has approved to regulate safety and health in federal OSHA's absence. In other words, the state takes over the federal OSHA's regulatory approach. Several of the state plan states have adopted usually industry-specific standards. California, Connecticut, Illinois, Maryland, Minnesota, New Jersey, and there's a couple of other states that the public sector is regulated by the state plan or the state itself, and they also include these regulations. All right. I mentioned the General Duty Clause, and a lot of folks don't necessarily know what the General Duty Clause is. It is, in essence, the catch-all for OSHA. And what it requires is that employers must provide a place of employment that is free from hazards that are first recognized by the employer, by the specific employer, or generally by the industry. So if there isn't a specific standard that says that you must do A, B, and C, if there is a recognition by an employer, by that industry, that this hazard exists, and there's no regulation that addresses it, and if it has the potential for causing death or serious physical harm, workplace violence falls under that quite easily. And it is, and this is the important part here, if it may be addressed or mitigated by feasible means, then OSHA, if you haven't taken those feasible means, can cite you for a violation of the General Duty Clause, just as it would cite you for any other violation of a regulation. I will say that General Duty Clause cases are a little bit more difficult for OSHA to bring. It's challenging for OSHA to bring those cases. It is easier for employers to defend themselves in a General Duty Clause case. But it has happened with workplace violence, and it is something that OSHA itself is committed to. And I want to share with you a very recent example, perhaps the best or most thorough decision on workplace violence that OSHA has prosecuted in essence. And it involves a healthcare facility in Colorado, actually a healthcare facility that specialized in mental health. And OSHA cited this employer after an employee complained. And if you don't have experience with OSHA, you will understand that, or you should understand that you'll see OSHA if an employee complains, if you're unlucky and something bad happens. Those are about the only three options for you. You're not going to see OSHA otherwise. In this case, it was a complaint. And this is what the allegation, or this is the citation, what the citation alleged. And I won't read it for you, but you can see that it is a series of violent incidents that occurred in the workplace over a period of time. And you turn to the next slide there. This is how Judge Augustine saw the case. It was a case ultimately about abatement. And these cases are about abatement. It's what did you do to address the workplace violence, particularly in these industries that are prone to work or more prone to workplace violence. It's about abatement. How do you fix it? And the bottom line, we can go to the next slide. Here is, this is how you fix it. This is a practical solution to it. I mentioned earlier that there's a tremendous amount of guidance. And that guidance is basically a roadmap to compliance. Even if it's not industry specific or specific to your industry, if you follow the guidance, then you will be in a much better position to deal with any workplace violence incident that arrives, any OSHA investigation of that incident. But it boils down to the basics of HR, really. It's have a policy. OSHA loves policies. A day without a policy or a day without writing is a day without sunshine for OSHA. So you need a written policy. You need to implement that policy. It should be consistent with OSHA guidance. Train, and then follow up to make sure that people understand what they're doing. Provide counseling, and then in certain cases, you need to provide security and the right amount of staffing. But that gets us into a lot of the employment law issues. And I would like to turn it over to Tracy to discuss those employment law issues that relate to that training, that follow-up, that reporting internally.
Absolutely, but first let's have our poll question. We've got a true or false here, making sure everyone's awake. Workplace violence is not an issue that should concern employers. True or false?
Should we perhaps go on while people answer
I guess we should go on. Yes, we can relay that information at the end. I know there's a little bit of a lag time, so let me go ahead and talk a little bit about what's been going on. We've heard a lot from the news media about violent scenarios, horrible things. We've dealt with school shootings. We've seen healthcare facilities. We've seen everything, shopping malls. I mean, the list goes on, and there's no way to possibly be able to take it all in, contain it. And there are numerous different opinions about how to best deal with it. And I'm seeing a sign that had
about 98%, a little over 98%.
98%? Yeah, I can't see that far.
I believe that workplace violence is a concern.
It is
should
a concern,
be a concern
yes.
for employers.
And I think that's very much the truth. Now, this is not something we're going to talk about a long time, but just because it is so recent, there was a law signed, the Bipartisan Safer Community Act of 2022 was signed into law back in June. And I know many had hoped there would be more guidance. It is a good start. It is the first major federal gun legislation act since the federal assault weapons ban of 1994. It has a focus on children and on mental health services. And it's going to change a little bit with the background checks. It's going to criminalize straw purchases. And hopefully it's a step in the right direction towards making this more of a national than a state-by-state type issue, which is one of the things that I know employers are struggling with the most, because various states have various approaches to gun laws and what employers can do relating directly back to how to control workplace violence within the workplace. Now, we had a wonderful group of summer associates this summer at Husch Blackwell, and we put them to the task, and they came back with a brilliant survey that provided us with a 50-state overview so we could understand how the laws varied from state to state. And specific things we had them look at were red flag laws, which I'll go into a little bit of depth about that in just a few moments, parking lot laws, and posting laws. And it's very unique to look at from the entire country's perspective how these laws vary. And it was very much eye-opening. And so what I would like to present here today to you all is kind of an overview of some of the things that we discovered. Now, red flag laws, as the name would imply, they are laws that allow police, family members, sometimes employers, and healthcare professionals to petition a court to take away someone's rights to have firearms or to possess those, oftentimes up to a year. And they greatly vary. And right now we know that there are at least 19 states that have something of this measure on the books in their state. And those include, as you can see from our map, California, Colorado, Connecticut, Delaware, Florida, Hawaii, Illinois, Indiana, Maryland, Massachusetts, Nevada, New Jersey, New Mexico, New York, Oregon, Rhode Island, Vermont, Virginia, and Washington. And you'll see a few moments down the way, there are other states such as Maine that have yellow flag laws. Some of these have more protections built in. There is a state that actually has an anti-red flag law. That's Oklahoma. And what you will see, the variations of these laws, most of the time they require that it be a police officer that petition. There is only one state that I noticed that actually allows the employer to do that, and that's California. And much as Brian was mentioning earlier, California kind of oftentimes leads the way in those types of matters, and that's really not surprising. Some of these states go so far as allowing roommates or household members to go ahead and alert the courts. But it almost always requires that the court be petitioned and that a review be conducted. In like Maine, for example, the yellow flag, it kind of takes back a little bit, has more of a conservative approach, requiring that the only police can petition the judge, and that it requires an outside medical assessment of the individual, and it must present evidence to a clear and convincing standard. So it's a little more conservative than some of the other jurisdictions, and it does vary greatly, but these laws are becoming more the norm. And I know that at the federal level, there have been discussion about having red flag laws across the states. And I would imagine that going forward in the future, we're going to see a lot of changes and probably a lot of variations. Some of these laws may be tailored to be a little more conservative. Others may be more broad in scope. But it's a step towards making sure that the people who have possession of these types of weapons have some oversight, and there's something that can be done if something is seen to be a potential issue. The next issue that we had looked at were parking lot laws. And this is going to be something that's very significant to employers, because a lot of times we'll see employers who want to pass a countrywide prohibition on employees being able to have firearms, say, in the trunk of their cars. And we've seen cases, I know I've personally handled a case where I had a soon-to-be former employee say to an employer in a termination meeting, I'm going to go out to my car and get my weapon. And these are things that have occurred, they do occur, and a lot of employers want to be able to plan and to make their workplace as safe as possible. And employers need to be aware that certain states have laws that specifically restrict an employer from restricting someone keeping a firearm in their trunk of the car or wherever the case may be. Most states that have these type of provisions will require that the person have a concealed carry permit, have some sort of, a hunting license, at least something that minimal. But there are numerous states, and I won't read you, we have the materials available, and we have this wonderful 50-state survey. Many of these states that have these types of restrictions or don't allow these types of restrictions.
Tracy, what did you recommend to the client, if you could share, when they called you and said that someone is on their way out to their car to get their
Well, that is obviously something that's going to be state by state. In this particular circumstance, and I practice in Texas, that is going to be, for the most part, something that needs to be for the most part, immediately acted upon.
Are there guns in Texas?
There are guns in Texas, yes. And this is something that we come up with, we see in Texas, and starting to see it across the, well, we've been for years and years, seeing it across the nation, and different states react to it in different ways. I know that this parking lot law slide, it shows we have different color codes. That is, disregard the colors. Where you're seeing that, these are states which we're trying to highlight the fact that these prohibitions exist, and companies need to be aware of these and how they institute their policies with their employees. I know we're running a little bit late on time. Couple other things I wanted to present before going to wrapping it up, and this is something that I'm sure most of you who are watching today are familiar with. Many education, colleges, school campuses, they have these provisions in place, and they do not allow weapons on campus. At the very least, they offer guidelines and have special codes that limit the ability to carry these types of items onto the campus. We're seeing more and more of that. In the education side of it, we're seeing special permit requirements. We're seeing a decrease in it. A lot of universities, particularly private universities, are just saying enough. We're not going to allow these weapons on our campus. And there are obviously very mixed feelings about this. One place where we have not seen as much, but we anticipate in the very near future, is the healthcare scene. And of course, there was the horrible shooting in Tulsa that I know everyone's familiar with. And a lot of these issues of workplace violence have come up in the hospital setting. It's a highly charged emotional setting. Several states have already put restrictions in place, such as Arkansas. Michigan has a pretty broad law, and New York has a pretty stringent law. And Texas has prohibited without written authority from the facility, which is kind of becoming a more common stance. Now, just going to potential liability for employers and bringing Brian back into the conversation a little bit, there have been recent cases that not necessarily workplace violence, but employees and their behaviors for employers, and reasons that should probably get the employers to pay very close attention to the signs and ways their employees are acting. One such case was in Texas. A jury awarded $7 billion in punitive damages, with a B. Yeah, I didn't stutter. $7 billion on based on the behavior of an employee outside of the work setting, someone that served customers. We're also seeing, a lot of questions arising. Was the employer on notice that such type of behavior was a possibility? Was the behavior foreseeable? And did the employer conduct a thorough background check? That is becoming a huge issue. I know for potential liability-wise for employers, the best practices, you want to listen, follow up on complaints, and make sure things you hear in the workplace, such as cursing, swearing, belittling, bullying, those can often be targets or signs that you have a person indicator who could potentially be violent and fall within the OSHA guidelines and keep you from having potential issues of going sideways with OSHA. Would you like to?
Yeah, I would say just to wrap up, that having a policy, sticking to that policy, particularly if you're in an industry or in an area, if you have certain risk factors that apply to your industry, and developing a plan with some thought ahead of time. And then thereafter, following good HR practice, investigating, taking seriously concerns that employees have about other employees, threats that may have been made in the workplace. I would encourage everyone to look at the OSHA guidance, to look at the Niosh guidance. There's quite a lot out there. There are many checklists, and we can certainly help you develop a plan if that's something that you would need. But we really appreciate your time today.
Yes, and it's been a pleasure speaking with everyone. We're going to go ahead and turn it back over to AJ.
Back to you, AJ.
Thank you so much. And thank you to everyone in our audience for joining us today. We hope the information was helpful to you and your organization. Just a few reminders before you depart. Program has been approved for HR and legal education hours. To report your hours, click on that CEU icon at the bottom of your screen. You will receive a certificate of attendance. It will include the course numbers, and it will be emailed to you tomorrow, along with a link for the recording of the webcast that you can watch and share. And then also, if you have not yet, please do take some time to fill out our short survey. Again, we like to use that information when we're developing the programming for our future webinars. And with that, that concludes our program. Thank you so much for joining.